Welcome, everyone. Thank you for attending our webinar concerning the Davis-Stirling Common Interest Development Act. My name is Danielle Ward. I'm one of the attorneys at the Blake Law Firm. We primarily specialize in real estate law, and we are located in Encinitas, California, but we handle matters throughout the state. I will be going over the Davis-Stirling Act. It's a comprehensive act concerning common interest developments. It covers more than 200 or so statutes, so this will just be some of the highlights. So today we'll go over the summary and the framework of the act, and then some of the key highlights as far as what are the homeowners' rights under the act, and then correspondingly, what are some of the association's responsibilities. Okay, so the Davis-Stirling Act was enacted in 1985 to provide a comprehensive and cohesive legal framework for the creation and governance of residential common interest developments in California. And the most common interest developments include condo projects and planned residential developments. So prior to the act, there were a number of statutes that applied to common interest developments, but they were scattered throughout the code, and it was difficult to read them together and harmonize them. So the act was developed to kind of provide an all-encompassing framework. So it is located in Civil Code sections 4,000 through 6,150 and is broken down into 11 categories, including the governing documents, ownership and transfer of interests, maintenance, finance, assessments, insurance and liability requirements, and then dispute resolution, are just a few of them. So the act allows developers of common interest developments to create homeowners associations, and those are the entities that govern the developments. They can either be a nonprofit corporation or an unincorporated association. And the HOA acts as a quasi-government entity, and the courts have even viewed them in that vein. And they govern various aspects of the homeowner's daily life within that development. So one of the documents, the Declaration of Covenants, Conditions, and Restrictions, which are recorded by the developers against the property, operate like the HOA's constitution. And from there, the board of directors are elected or appointed, and they govern the HOA. So in addition to the Davis-Stirling Act and the CC&Rs, HOAs often are governed by board adopted bylaws and rules and regulations. And the act sets forth the boundaries for these governing documents, and to the extent that any of them conflict, the act will prevail. One of the primary functions of the act is to safeguard the individual owners within those common interest developments, and several of the provisions are set forth to provide homeowners rights and access to the HOA's operations and documents. So access is one of the key features for these homeowners. It provides extensive, although not unfettered, access to association business. Homeowners are entitled to review and request a wide variety of association records, including budgets, tax returns, reserve summaries, vendor contracts, income and expense sheets, and agendas and meeting minutes. And there are some penalties if the homeowners associations do not comply with these homeowner requests. So they should be taken seriously. And then with the exception of executive sessions, board meetings must be open to the homeowners, and only official board meetings is the place where they can conduct business. So they can't conduct via email or outside the presence of an open session. So enforcement, to the extent that the HOA is not following its governing documents or the act, members can bring legal action against the HOA, and they can also bring legal action against other members for violating the CC&Rs. And to the extent that a homeowner prevails against an association, they may be entitled to recover their reasonable attorney's fees. Okay, so while there's lots of access provided to the individual owners, the homeowners association itself is granted a wide variety of power to govern that common interest development. And with that, there are several responsibilities. I've outlined just a few of them, but a good portion of the act outlines all of the things that the HOA is required to do. And in doing so, they have to follow their fiduciary obligations to the members. The board members owe fiduciary duties to the members and the association, and they must exercise their duties in good faith and with due care. So some of the requirements is that an HOA must adopt election rules, and they must have specific criteria that are aimed at providing equal access to media, common area spaces, and transparency of the specifications for candidacy, voting power, and appointment of third-party inspectors. Maintenance. Homeowners associations are responsible for keeping common areas in good repair. They can be liable for injury sustained, so they should engage in regular inspections of the development. And more specifically, every 3 years, an HOA must prepare a reserve study that analyzes the remaining useful life of various components in those common areas. Homeowners associations have a duty to collect regular assessments that are sufficient to cover their obligations for the development. So that would include all of the maintenance obligations and studies for the useful life. If a homeowner member fails to pay their assessments, the HOA is entitled to report a lien against the property. However, before the HOA can proceed to foreclose on that lien, there are several steps that they must take before taking that legal action. One of the big issues that HOAs face is with concerns of homeowners wanting to update their homes, and that deals with the architectural standards. So the board or an architectural committee, which is generated usually amongst homeowners or board members, can impose rules regarding the improvement of the exterior of the home, and that are usually in line with the governing documents and to maintain the character of the neighborhood. In many of the planned developments, there's certain color schemes or architectural details that they want to keep consistent. And then both approval of homeowner requests and enforcement of architectural restrictions must be in good faith and not arbitrary or capricious. So the homeowners association must follow detailed guidelines, and they must enforce them uniformly amongst the homeowners. In recent years, there's several amendments to the act that went into effect. Some of them, the larger ones, concern election rules and processes, management of association funds, restrictions on rental terms, and notices to members. So while the act is pretty broad and all-encompassing, it has been the subject of various amendments over the years that either change or add to the obligations. So it's important for HOAs to constantly check that their governing documents and all of the operations of that HOA comply with the act, particularly as it evolves, and to ensure that all of their documents are up to date. That is the end of the presentation. Thank you so much to everyone for joining us. And I'm going to put up some contact information. We would welcome any questions about the Davis-Stirling Act, or if you have any questions regarding any of your real estate property needs, the attorneys at the Blake Law Firm are standing by to help you. We also do offer customized legal education, so feel free to reach out if you think that an in-person webinar or a lunch and learn or even Zoom would be something that your company or team or association would benefit from. Thank you, everyone. That's all.